The proposals that have been made by the government in its consultation paper, which was issued in November, suggest that a figure of £350 million needs to be saved and will be saved from legal aid. The largest group of people who this will affect will be the public themselves. There will be £274 million proposed to be saved from taking away legal aid from those who would otherwise and currently be eligible. The cut to the legal profession, which comes in at about 136 million, is significantly less than the cost to the public. So clearly, the biggest loser will be the public.
Yeah, but I'm talking about savings to the exchequer, savings to the taxpayer. The Bar Council is suggesting that cutting legal aid would actually add to costs rather than cut costs. That's what I'm puzzled by.
The government make a number of assumptions about how their proposals will play out in practice. They make, first of all, an assumption that people will choose not to go to law. And in that, we say, well, it's not just a matter of choice. A number of people won't go to law because they have learning disabilities, they have mental health problems, they are simply unable to access the courts. The second assumption they make is that people will mediate their problems. And again, we have some reservations about the number of cases which will be successful mediated.
And the other one is the vexatious complaint. I mean, there are people who go to court just because they can and because the state will pay.
There is a group of people who fall into that category, but in the far-ranging cuts that the government propose here, there will be something like 90,000 cases in our estimation, of which affect families, which will be taken away from the scope of legal aid. Now, those are not vexatious litigants. Those are people who have a legitimate claim to promote and enhance their family life. Those are people who may be facing serious allegations of physical or sexual abuse within the family courts, which is affecting the way their families are functioning. Those are people who will be denied legal aid under the proposals. And what we say is that if you remove an area of legal redress, you cut out this large number of people who have legitimate claims in the courts. It doesn't resolve the problem. It simply pushes the problem into a different service. So you will have huge social and economic costs.
Right, so it's the much broader picture that you're looking at. You're saying, yes, it might save money in legal fees, but there will be other costs concomitant.
It's a little of that, John, but it is also this. The government has, in our view, not paid proper attention to the immediate costs that will be faced by Her Majesty's Court Service, the court service itself. If you populate the courts with large numbers of litigants in person, inevitably, in our view, the court service begins to grind more slowly. And in their proposals, the government suggests that it may be the case, they say, that there will be delays in proceedings. There may be poorer outcomes for litigants. There may be increased court costs. Anyone who works in the court service who on a day-to-day basis will tell you that those are the inevitable consequences of the proposals, not the potential consequences of the proposals. And within the government consultation, it is suggested that the government is about to or is currently undertaking research on the impact on the courts of this increased number of litigants in person. Why hasn't that been done
very quickly
before?
Why hasn't it been done? Oh, I see. So what you're saying is do it now and then we'll talk about it rather than make the cuts first.
We would have expected that step would have been taken before these far-ranging proposals had been put before the public.